Hi folks, this is Dr. Kyle Usrey, your professor in Law 518. I want to give you a little bit of history and context of the U.S. Constitution. Before the U.S. Constitution was ratified in 1789, it was preceded by something called the Articles of Confederation, a document that governed the 13 new states of the country in a loose league between 1781 until 1789. These Articles of Confederation were in effect during the War of Independence, our Revolutionary War. Having experienced abuses at the hands of a strong central government and a tyrannical monarchy, the founders of the United States chose to have a weak central government and left most of the power under those articles to the states. There was no provision under those articles for an executive branch to enforce the laws, nor was there a national court system to interpret the laws. The Congress was the sole organ of the new national government, but it had no power to enforce laws over the states, and it had no taxing power. So how do you pay for a war without taxes from a central government? This lack of central government power of any real measure resulted also in tariff wars, a mess in foreign affairs, and a unicameral legislature instead of the bicameral system that we now have. Thus there appeared to be a pressing need for some central government powers, and thus work began on constructing a new constitution, which was put together and then proposed in 1787 for ratification. The legislative history is mostly based around the Federalist Papers, over 80 essays written by James Madison, Alexander Hamilton, yes, that Hamilton in the recent popular musical, and John Jay, who later became the first Chief Justice of the Supreme Court. The Federalist Papers were designed to promote ratification of the U.S. Constitution and act as an important source for interpreting the Constitution and its original intent. They were first published in the New York press in 1787 through 1789 and even into 1790. The primary organizational structure, protections, and powers in the U.S. Constitution is based on two components. First, the design of express delegated powers to and between three competing branches, which provided some types of checks and balances between those three branches, legislative, executive, and judiciary. And then secondly, the first 10 amendments, also known as the Bill of Rights, to protect individual liberties from federal government intervention. It was originally thought that the first 10 amendments were not needed, that the Constitution's articles provided protections to individuals, but it became clear that the U.S. Constitution would not be ratified without them. While there are many contributors to the drafting of the U.S. Constitution, it's James Madison who's often called the father of the Constitution because of his pivotal role in drafting its articles and then its first 10 amendments. Plus, he was hugely instrumental in getting it ratified. If you're so interested, I think it would be beneficial for you to read essays number 10 and number 51 of the Federalist Papers by Madison. Essay number 10 dealt with issues of majority versus minority rule. And in fact, law students and lawyers are told that the main purpose of the Constitution is to protect minority groups of people from the excesses or tyranny of the majority. We don't have a pure democracy, since that would entail just majority rule at all times. Instead, we have a democratic constitutional republic as our governing political system. Anyway, essay number 51, written by Madison, deals with separation of powers of the three branches. Also of interest are essays number 70 and 78, written by Alexander Hamilton. Essay number 70 makes a good case for a strong executive leader, as opposed to the weak leadership under the Articles of Confederation. And essay number 78 deals with the structure of the judiciary, one of 6 essays written by Hamilton on the subject of the judiciary. You'll know that there's a preamble to the Constitution. You should read it carefully. Many people are confused about the role of the Declaration of Independence, written mostly by Thomas Jefferson. The Declaration of Independence was written in 1776, 11 years before the new U.S. Constitution was proposed. James Madison at one time wanted to do a preamble to the U.S. Constitution, incorporating the Declaration of Independence. That proved not to be feasible, a non-starter, if you will, so that was abandoned in terms of getting the Constitution ratified. By the way, Thomas Jefferson was in Paris as ambassador during this entire time of the creation and ratification of the U.S. Constitution. And in getting it ratified, Not much input came from him at all, without the modern communication tools that we have today, because it took days to get any letters from the European continent back to the United States, and vice versa. Therefore, it's been long held that by the U.S. Supreme Court that the Declaration of Independence has practically no legal precedential value as legal history to the U.S. Constitution. No decision of the U.S. Supreme Court has ever been based on the Declaration of Independence. For many people, that's amazing. The purpose of the Declaration was to make a case for independence from Great Britain, not to create a government structure for the new nation. The U.S. Constitution thus centers around limited powers of the federal government, trying to find a balance between the horrors of the tyrannical monarchy central government that governed the 13 colonies under King George III of England, and then on the other hand, the ineffectual weaknesses of the Articles of Confederation, or no central government power to speak of whatsoever. Thus, a new approach was needed at a careful delineation of prescribed powers of the three branches of the government at the federal level. All other powers were to devolve to the states and the people under the 10th Amendment, which we will talk about later in Session 3. An important but often overlooked component of the U.S. Constitution is state action. I'm going to try and explain it. In order for there to be an issue to be considered for constitutional review, there must be some law or ordinance or regulation by some arm of government, either federal, state, or local. This concept of state action applies to agencies as well. So agencies such as the SEC, the FCC, the FDA, the FAA, the EPA, and many others, state and local and federal, are seen as state action. Their pronouncements, their regulations are seen as state action, and thus subject to constitutional review. The Constitution is thus a type of rubric or ruler against which any state action is evaluated for legality. If such state action comes up short in its measurement against the U.S. Constitution, then that state action or law or regulation or ordinance, etc., is struck down. An example of state action or non-state action, if you will, is the controversy surrounding the kneeling of football players at the playing of our national anthem before NFL games. Mistakenly, many people think this is a First Amendment issue. It's not. And that is because there's no state action involved. NFL games are the result of private corporations competing in sport, and their private associations, organizations competing in football games amidst leagues, in this case, the NFL. No state action is involved. No law, no ordinance, no regulation from any federal, state, or local government is directly involved in those games or organizational contractual relationships between those teams. Therefore, the U.S. Constitution is not implicated, and that includes the First Amendment dealing with freedom of speech. The First Amendment is not implicated at all in those kneeling controversies because there's no state action. Later on, we'll examine the parameters of the First Amendment dealing with free speech, freedom of the press, freedom of association and assembly, freedom of religion, and freedom to petition the government, with primarily a focus on free speech and freedom of religion. We'll also examine carefully the two primary means or theories of interpretation of the Constitution, one of which looks at original intent, which we just introduced. And that particular theory of interpretation is called an originalist view. We'll also look closely at something called states' rights and its reestablishment by Justice William Rehnquist and later Justice Scalia under the 10th Amendment. All of these issues are relevant to many sociological and geopolitical issues that have become hot-button issues in our society in this day and age, and thus impacting the rest of the world. They require a close examination of leadership within government and any limitations on that extreme power, an important issue that we all need to be thinking about in this day and age. Thank you, Dr. Kyle Usrey.